Hi, and welcome to the Why Should I Care Civil Procedure Podcast. I'm Alexandra Lahav, your host, and today we have a wonderful guest, Professor Seth Endo of the University of Florida. And the question for you, Professor Endo, is why should we care about civil discovery?
Wonderful. So many reasons, and I'll start really with three categories of reasons and dive into each one. The first category I think of that is that discovery is really a defining feature of modern American litigation. The Federal Rules of Civil Procedure in the 1930s brought robust discovery into being. And to this day, most other countries don't have the same sort of expansive party-driven process. Uniqueness on its own might not be enough to warrant interest for folks who are not civil procedure fans. But here, discovery as a feature of US litigation also tells us about just how much the system values adversarialism. So the notion that self-motivated antagonistic parties will drive the truth-seeking function of litigation, while at the same time, it also requires some sort of self-policing and sharing and cooperation by the litigants and their counsel to make it work. So there's this really interesting tension. And then one also sees procedural due process values embedded in discovery's main rule, Rule 26, and the governing doctrine that tries to balance accuracy, efficiency, and participation, the latter of which can cut either for or against expensive discovery because it includes both privacy and dignity interests. So that's one big category. Second, I'd say, is the instrumentalist value. And maybe for most, this is where it really will do the work. But discovery is where a lot of civil litigation happens in practice. In a notice pleading system, parties might not have all of the information necessary to prosecute or defend a claim at the start of a case. And that means the availability of discovery is going to be really meaningful and have potentially an outcome dispositive impact in the litigation. And then in a world in which civil cases rarely proceed to trial, discovery takes on even more importance because parties will rely on the information uncovered in discovery in their dispositive motions and in settlement negotiations. And just to give you a sense of this, or the students, the last numbers I found, although they might be a bit out of date, they should give you some sense of the picture of this. From the Federal Judicial Center, less than 2% of cases go to verdict. And then after Twombly and Iqbal, I think about 14% of cases are disposed of at the motion to dismiss stage. So right, that leaves about 84% that are resolved between the motion to dismiss and verdict. And that leaves open the possibility, and presumably most of these are going to engage in some discovery. The other instrumentalist value, which I think is a little bit different than just how it affects the case and the case negotiations, but is this notion that discovery may also amplify the voice of litigants even when the information exchange doesn't change the outcome. So on the positive side of this, one can think about how by allowing the parties to tell their story and to learn more from their adversaries, discovery can add to the dignity afforded to the parties, really conveying an acknowledgement of the worth of an affected entity's voice. And win or lose, that sort of participatory discovery system likely contributes to a party's satisfaction with the outcome. And the exchange of information may even lead to some reconciliation between the parties if, for example, the plaintiffs learn about the weaknesses in their case or the strengths of the defenses, or vice versa. Now, on the negative side, although there are some formal constraints to this, discovery may also be used as a weapon by imposing high costs on the respondent or by intrusively inquiring into marginally relevant, embarrassing, or private aspects of a litigant's personal or professional life. So I think of that as the sort of instrumentalist category. The last, which I think ties into this, though, is that discovery is what litigators do in practice. Discovery is how most litigators spend most of their time, and that explains why, whether warranted or not, discovery is perceived as a major cost center, but also just as a student, as one thinks about what comes next, probably a lot of it's going to be discovery.
Thanks. So I want to talk a little bit about this privacy issue. So in two of your categories, right, we had sort of the values category and the instrumentalist, how can I use it category, right?
Yep.
You mentioned privacy interests. And so I want to talk a little bit more about that. And I think in order to talk about that, we need to know a tiny bit about the scope of discovery. So how much can you get from the other side? And then how much of it infringes on people's privacy interests. So I was wondering if you could talk for a couple minutes about those questions.
For sure. So Federal Rule of Civil Procedure 26 sets forth the scope of discovery, and it permits the litigants to seek information that's relevant. And it sets some limits, though, right, for privilege. And then also it protects against unduly burdensome requests, which can include ones that are overly intrusive. So it's pretty broad, right? And that's one of those defining features. But there are certainly limits, and litigants can move for protective orders to prevent that kind of intrusive discovery. Just to make that more concrete, there was a pretty big case from the Supreme Court recently involving Title VII and whether it covered individuals who are transgender. And in that case, or one of the cases that was consolidated for the Supreme Court appeal, in one of the cases, a funeral home fired an individual for being transgender. And as part of their discovery requests, they asked the transgender individual about the physical genitalia that they had, their relationship with their spouse, and a lot of things that really seem to go to the individual's private life. And then when the judge asked about what work was it doing, for the actual legal claim, it turned out, very little. And so there, that was discovery being sought by the defendant. So the plaintiff sought the protective order and received it.
And so would you say that's one of the, I don't know if rare is the right word to use because we don't have a lot of data on this, but would you say that's an example of that the discovery just wasn't relevant to the claim or defense? Because that's the first step, right? When you're asking for something, is you have to show, well, this is relevant to the claim or defense that I'm going to be prosecuting or that I'm going to be defending if this case goes to trial. And you said it never goes to trial, but I always joke with my students that nobody ever goes to trial, but 100% of everybody threatens to go to trial, right? So you have to be able to say, well, if I went to trial, I would need this information. So do you think this example is an example of just it wasn't relevant? And just to be explicit, what do we think the defendant was doing if they're not seeking relevant information?
Right. So I think that brings up some really interesting questions, and it's hard to know. In the case, one of the claims brought by the plaintiff was that they were fired for being transgender, and that violated Title VII's equal protection. So to that, then, one of the questions, at least that the defendant claimed, was, what does it mean to be transgender? And to the extent that the defendant was taking a position that it really spoke to a physical transformation, then, right, one would imagine that would be relevant. But that was essentially would require the court then to have accepted the theory of the case from the defendant. Now, the court, before getting to the substantive rulings, might then say, okay, I'll allow it. And I suspect that's mostly what happens. In that case, though, that claim had dropped out. And so at that point, the court was able to inquire, what work would it do? And there, right, the defendant said, well, there's no live claim that it speaks to, but it could come back and it will help inform our broader litigation strategy. And I think that that's where you see that, when there's in effect, a marginal call, where these things, where the different elements or factors work together. So the fact that it was only marginally relevant, and then that it was highly intrusive, right, I think showed how the judge was thinking about it along that sliding scale.
And do you so when you're thinking about how judges, so I think one of the things we're learning here is that the standards for discovery are discretionary. So while some of the individual discovery rules do have these waivable limits, so the number of interrogatories are listed, but you can waive that number, those kind of things. The judge has a lot of discretion about what to allow. So what do you think about what those limits should be. So should we be more parsimonious in grant, or should judges rather, not, we don't have the opportunity to grant anybody discovery, but should judges be more parsimonious? Should they be more generous? How should students think about those policy questions which seem to be go to the core of discovery? Because to me, when I think about it, a lot of our policy thoughts about discovery, as you mentioned at the beginning, they're influenced by the fact that we know that what's driving it is the self-interest of litigants. And it's really the judge's job to look at the system and say, well, is this good for the system for me to let you have this information, right? But I wonder, what do you think about those policy issues, and what can you say to help us think through them?
Yeah. So first I'll start. I think that my friends and family who are defense attorneys would look at my writing and say, well, this is a guy who definitely believes in way too much discovery. But I think that really, when it comes down to it, what I think would be best, and I think that it's hard to see because judges have so much discretion, and this happens without much appellate review, um, is that what I would love to see is actually judges just doing a lot more of the unpacking. As it stands, even when there's a formal discovery dispute and in order, judges very rarely get explicitly into the trade-offs. And I think that's actually one of the things that makes it so challenging for students, is that the formal law itself is often trying to do this really difficult balancing of those competing interests at this, and they're trying to manage that for the parties. At the same time, the jurisprudence frequently aligns this, treating the legal questions as issues of pure textual interpretation. And you can see a bit of that even, for example, in Iqbal, right, where in some fashion, the majority opinion is saying this is just about Rule 8, right? So not actually about discovery, but just as a civil procedure example, the language of Rule 8, but it was actually, right, as described, in part about what are the pressures in terms of time and money that discovery are placing on the litigants, and what are we doing with procedure to channel that?
So I want to suggest to you, and I want to hear your reaction to this, that our intuitions about how much discovery there should be, so what documents that are maybe embarrassing or just private in the way you're describing with the Title VII case, should be allowed to be asked for, right, or to be required to be released. They might depend on what the nature of the case is and who the litigants are. And the thing that makes me think of that is your use of Iqbal as an example. So one of the things about Iqbal is that one of the things that the Supreme Court was worried that the plaintiffs would do was depose former Attorney General John Ashcroft. And there's a concern about the cost of having high-level governmental officials be deposed in particular. And so I think that is a big part of the story of why the court was concerned enough to take a pleadings case. And I wonder what you think about that, because it ties into a theme in civil procedure, which is the transsubstantivity of procedural rules, that the rules apply the same in every case. And then the judges have to decide, well, how am I going to apply the rule using my discretion in this particular case? What is your gut instinct about the way that judges should think about the particular fact situation when they're making these discovery determinations? That is, should we be more worried about fact situations where somebody might be, for example, humiliated, or where somebody's a really important governmental officer? Or should we apply the rules the same no matter what?
I think the former, right? That the rules as they're structured, and in giving the discretion to the district courts, at least in the federal system, are really trying to do that work of saying, how does this apply in this particular circumstance? What is the balance with these particular facts? With that said, I think that judges' willingness to engage in that balancing explicitly rarely happens. And I think that that makes it harder to have one, predictability, right, about what's going to happen, and two, a sense of legitimacy that these discretionary calls are really doing justice. And so basically, I think, in part, I just want to make work for judges. But I think we'll actually have a really positive system-wide effect. The other thing I'll throw out there, keeping on the privacy example, it is the notion that judges actually have a lot of tools. And I think this is actually one of the other challenges of studying discovery in law school, but it becomes much, much more apparent once one's out into practice, is just how many tools judges have to manage this. So for example, privacy, judges can also, depending on the nature of the request and the stage of the litigation, issue a confidentiality order or a sealing order, and therefore protect the information from being widely disseminated or being used outside of the litigation. Judges often will have discretion to shift costs. And so with government officials, it's not just the amount of money, right? It's this sort of attention and the distraction from the public function. But one could imagine, that there are creative ways of structuring depositions or otherwise to get around that, and that there's a lot of freedom for judges to do that. And so the more that they explain it, I think the better. The Supreme Court, of course, is speaking to courts and trying to give them more guidance. So it makes sense that they talk in a different way, even if one believes, as I do, that the individual facts of the case might very well be animating the decision.
And that some of what you said there brings me to my second question. So in addition to wanting to know why we should care, I want to ask you, what do you think students struggle with the most when they're learning about civil discovery? And do you have any advice for students who are in their 1L year and they're struggling with Rule 26? What can you tell them to help them out a little bit?
For sure. So first, I'm just excited by that question because it presupposes that discovery is going to be covered in civil procedure. It's not always covered, even though I think it's this really important aspect of civil procedure. So right there, I think already that's a win. But I do think, as I was describing, right, the way the formal law works and how it aligns some of those interests can be really difficult, paired with that it's hard to get a concrete sense of discovery because you have a whole bunch of different devices that operate in a manner that's both mutually informative and iterative. And so students often aren't going to really see that and see how those tactical moves are playing out. I know I didn't see discovery requests until really 2 years out of law school. So after graduating from law school and doing a clerkship, and then finally being a little more elbows deep into the early stages of a case was the first time that I saw discovery requests.
So let's just take a couple minutes and talk about, because I think it's really interesting, the idea that discovery rules are iterative and that we use all these tools together. So you memorize when you're in 1L a bunch of different discovery tools, if your professor, I guess, teaches it. Right, so you have interrogatories and depositions, requests to admit, document requests. And how do you think students should think about those things? So, one of the things is that I don't know how many professors even test about discovery, right? That's a question for students who are thinking strategically. But we have one, right, and two. But as you said, when you get into practice, discovery is really important. And I want to suggest it's not just important if you're a litigator, but it's also important if you're a transactional lawyer, because when you're working with a client, they're producing in their interactions with each other a lot of information. Now, not in their interactions with you because there's attorney-client privilege, but they're producing a lot of information that may later end up being useful to the other side in litigation. And so there's lots of ways in which thinking about a potential for litigation, even for a transactional lawyer or an in-house lawyer, is going to be an important thing to be aware of. But
Oh,
right, but I want to get back to this idea that I have so many different things that could be asked for. What's a good way to think about those things? Like one thing I was thinking is, well, you could make a list of them all. And the problem with that is then I have a list, but I don't really think of how they interact. So if you will indulge me, I'd love for you to give us an example of how you might use a couple of these different, if you can do it off the cuff, a couple of these different tools and how they might benefit a litigant, rather than just thinking, oh, well, I want to depose John Ashcroft, right? But maybe there's other things you might do that would help us understand how these things interrelate.
absolutely. And I think that actually just the calling out, right, the interrelatedness is such an important part. And so as a student, I think if you understand the importance of discovery and it's where it sits in the stages of litigation, and then its interconnectedness with the other rules, right? So just even thinking about its connection with Iqbal and how that ties to notice pleading, I think that ideally will help one understand the rhetorical moves in the case law. But then to get to sort of some of the more tactical elements, I know that I found it really helpful as a student and now in teaching it to look at the structure of Section 5 of the Federal Rules of Civil Procedure, which really focus in on discovery. So as we talked a bit about, Rule 26 defines the scope and sets forth many of the procedures and protections. And I think getting one's arms around that notion of the focus on relevance, which also now includes proportionality, but how it ties to privilege and undue burden, that in some ways sets out the general rule of discovery because everything else is basically implementing it in different ways. But then when you think about the different tools and how they work, again, I think it's sort of almost go down the list. So I'll stick with Rule 26 first, just for 1 second, which is to say, it requires the parties, right, to meet right at the front end to figure out a discovery plan. And so I think that gives one a sense of how much is left to the parties and their interactions. And it also speaks, I think, partly to what you're saying, or to echo that, right? Like one could just make a list, but it doesn't really quite do the work because you actually have to be thinking about a plan of how am I going to use it? What is the information I need to tell the story that is going to have traction and ideally get the client where the client wants to go? And so one can look at the rules, right? And essentially, I think almost follow through them. So one could imagine that one learns the name of a potential witness or the existence of an important document, right, that might speak to the liability of a party, either in initial disclosures or interrogatories. And then one asks for a copy of the, let's say it's a document, one asks for a copy of the document to be produced, and then one sort of thinks about how that fits with their theory of the case, and then puts that together in a deposition in which one asks a witness about issues raised by the document. Maybe in doing that, the witness refers to another document that wasn't produced for whatever reason, and then that may start the cycle all over again, right? And all of that's being done with an eye towards how does this fit either to prove a substantive point or potentially for impeachment for a dispositive motion? How does this, in light of how it might affect the odds either with the dispositive motion or if it gets to trial, how does that change the bargaining range for settlement? So hopefully that's one way people can sort of see that, see the iteration. The other thing I think in terms of making sense of it is that as a student, one might not have a sense of it, but in practice, at least anecdotally, what I saw is that discovery typically occurred in stages that proceeded from the cheaper or easier to do to the more expensive and the more likely to be contested or intrusive. And so figuring out how can you use the former to lay the groundwork for the latter, I think is also important and makes sense in part of some of the jurisprudence and why it might look different when talking about depositions versus interrogatories.
Right. So you might use interrogatories, which are just questions about, specific questions to the other side, or even request to admit first to try to lay some groundwork, then ask for documents, and then do depositions, which I consider to be among the more expensive things to do. But you can't, you're not going to be allowed to depose someone twice. So you want to try to get all the information you can get to prepare for that deposition, so that when you're doing your expensive deposition, you don't find yourself having missed something really important. And I think you've hit upon what I think is the biggest challenge, which is that as a student, when you're learning about discovery, you're not doing it, you're just learning about it. And yet it's in the context of a specific case that we really can think, well, do I have any questions, or do I just that I can write down and get a written answer to, or do I really need to have this person in the room in order to get the information that I need? And that is hard to do in an abstract way. You really need to be thinking through a particular case in order to understand it. I think that's the biggest, to me, that's the biggest challenge of understanding discovery. Well, any last words before we close? This has been really enlightening, and I really appreciate your time.
I'll just throw out, if I may, a couple of thoughts about also why discovery is exciting. Is, that I also think it's a place where basically all the cutting edge issues of civil procedure are also being hashed out with discovery. So I mentioned privacy issues and confidentiality orders. I think the Me Too movement has made clear how confidential discovery can have a real impact on public health and safety. And so both through local rules and otherwise, some sunshine acts in states, we see that having an influence on discovery. With the Black Lives Matter movement, I think that has helped bring to the fore how certain structures reinforce existing structural power dynamics. And in that, nearly every judge one gets to talk about this will admit that they don't like supervising discovery fights. That actually means that a lot is left to the parties, and sort of that there might be these kind of gender, racial, or economic power imbalances. There's the digital world, how discovery manages social media is giant, public access to dockets, the growth of electronically stored information, and as part of that, how it's managed by AI is all happening now. Another big trend, just again in litigation, but globalization also is playing out in discovery. So the use of American discovery, which again, most other countries don't have, but there's a mechanism by which entities engaged in foreign court proceedings can use American discovery. And that's become a fairly big issue. The European Union's General Data Protection Regulation may also be raising some issues about how that interacts with American discovery. So basically, anything that's happening in the world and that's happening in litigation is also happening in discovery. And so I hope people find it as interesting and as fun as I do.
Yeah, that's very cool. And it sounds, and one of the things that you just said raised for me how it can cut both ways. So you could have a situation where, having information be hidden is really hurtful to a victim who's not able to know, oh, there are all these other victims out there of this same tortfeasor, for example, or employment law violator, on the one hand. And then you have the other, which is the example that we began with, which is when discovery asks for information that may be embarrassing or humiliating to the person who's alleging that they were wronged. And so there's a way in which this desire for information can cut both ways. And I agree with you that the issues of electronic discovery and the electronic world we live in, as well as the new issues with this transnational information, flows of information. There's a lot of ways in which it's a whole new world, and there's a lot of employment opportunities for students in working both within law firms and in other organizations that help law firms manage discovery. So there's lots of reasons to be interested in it, both instrumental and more intellectual.
And if I may actually add on one more thing, when you were describing that example and how it can cut both ways, it also actually makes me think about the rise of multi-district litigation in which federal civil cases which are related can be transferred to one judge for pretrial proceedings. Right. One of the things that brings out is what is litigation for? And one of the ways that's being hashed out is through discovery fights, right? Is litigation in part in the US, I think most people understand it as a substitute for regulation, right? We give a lot to private actors to say, try and hold these people accountable. And in the discovery, that plays out in the discovery context, because one of the questions is, if we're thinking about is the value of discovery proportional to its cost? It leaves open this really giant first order question of what's the denominator compared to what? Is it the value in the case, the value in all similar cases, the value to society in terms of its regulatory effect, or what it would cost otherwise to make regulators do this, right? Which is fundamentally asking, in a sense, what are courts for? And that's happening here in discovery. And so just when you said that, it made me think, oh, right, something that ties, at least for me, both these really amazingly fun and difficult first order theoretical questions, but that have real traction. The Sixth Circuit and the national opiate litigation, right, just address this.
Yeah, so that's too complicated for us to get into now, but absolutely, there's a lot of really big cases where the whole case will turn on what evidence you're able to get in discovery. And so all of these questions about how and when become really pivotal to substantive outcomes. Well, thank you so much. This has been great, and I hope to have you on again. And I really appreciate your taking the time to tell us why we should care about civil discovery.
Such a pleasure. Thank you.